Let's go ahead and start this meeting. I so appreciate you guys being here. We have established a quorum. So I'm going to call State Planning and Community Affairs to order. What's today, the 3rd? March 3rd. So Chairman Carpenter, if you will take it away. Is it that one? Yeah.
Thank you so much, Chairman. Ladies and gentlemen of the committee, House Bill 689 seeks to establish a homelessness prevention program under the direction of DCA. As many of you know, there was a lot of ARPA money sent to the state of Georgia to help its citizens with rent relief during COVID. The funds for this program will run out in September of this year, but the need is as big as ever. Rising rents, rising food costs have crippled the pocket of many in this state. This program seeks to help as many as it can by providing state grants to local organizations throughout the state. This arrangement will leverage local buy-in with it so that organizations can utilize both local monies given by private sector and local governments, and will provide geographical distribution so that one area of the state does not control the majority of these funds. This legislation simply provides a framework for how this will occur, and will only happen if the Appropriation Committee sees it fit. Emergency rental assistance has helped over 61,000 people remain in their homes between the years of 21 and 23, and I'm sure we all understand the consequences of evictions on families and especially children. While this program will not solve all of these issues, it does provide a glimmer of hope to those who need it the most. And I'll be glad to go through the bill itself, but basically all it does is it provides a program under DCA similar to what they've been doing already with the ARPA funds, but it just provides an opportunity for the state, if it sees fit, to fund such programming for there to be a continuation of it, because currently there's nothing that would allow this to occur without the ARPA funds.
Thank you. Representative Griffin, what number is that? 7?
And I think I haven't gotten mine in, but she got 6. Yours was
I think you were practically trying to get in.
Oh, okay. Sorry about that. Okay, you know, I haven't read this bill. So explain to me again now. There's something already in place.
Yes.
Right.
So there's currently a provision from federal government funding that DCA was given the opportunity to disperse across the state, and they did a lot of that through free legal aid services to provide rental assistance for people that from the COVID money. That is drying up in September, and there's no state mechanism for that. That's all federal funds, and so this would create the mechanism under DCA for us in the future, if we so see it fit, to fund it from a state level. It would also allow them to continue to accept federal money if available, but this is just the state version of that federal money.
And one other question for me, Madam Chair. So what the bill is stating, it has to pass. We have to pass this bill before any appropriation can take place.
That's correct. So there's no fiscal note on this legislation as it sits today, because it would only be upon appropriation, and that would occur through the appropriation process. But this just creates the mechanism, who they're allowed to partner with at the local level, et cetera.
Follow up.
Yeah.
So there is a possibility that appropriation can take place during this session?
Maybe. Yeah. I mean, there's ongoing talks.
Who would submit that?
That would just be a conversation between the appropriations chairmans.
No. Someone would have to request it. Who
DCA.
would request?
Yeah, it would go through the DC. It would go through the line items under DCA. Yes, sir.
Okay. All right. Thank you.
Thank you. Representative Barry?
Thank you, Chairwoman. Representative Carpenter, I think this is a great bill. Thank you for bringing this bill to us. I was reading it last night. I just had one quick question, because we know that there's been some issues with the State Housing Trust Fund, as you know, with getting the money out as fast as it could be or and not meeting the standards. Will this help increase the effectiveness of the State Housing Trust Fund?
No, it actually just creates a whole nother program, so that it's separate, and would be focused on if you can't meet any of the other qualifications for the other programs, this would be available to you. So it actually opens up a subset of folks that currently don't fit into the other programs, if you will.
Thank you.
Thank you,
Great bill.
Representative Barry. Representative Jones?
Thank you, Chairman Bethia. Chairman Carpenter, quick question. Will there be any provisions for those that are already in the homeless state to be able to receive any funding from this foreseeable program?
No, no. So actually, as it sits right now, this would be an eviction type assistance program. So hopefully the key is to stop the flow of people before they get to the homeless state. I think there's other programs out there to address those issues, but this is trying to say if you spend money on the front side, it's a whole lot more efficient than on the back side.
Thank you, Representative Jones. Representative Kahan?
Thank you for this bill. This is a very important issue in our state and across the country. Do you know what the projected cost might be? Do you know what the ARPA funds were last year?
They're running through about $2 million a month right now. This is not going to touch that. We wouldn't. I think this is an opportunity to have a conversation with appropriations about, hey, what is a number? Is it 500,000? Is it $1 million? I don't think there would be an appetite to put $24 million in the budget for this program, but I think some funds and then show. You know, I'm a big fan of funding things small, show their successes, and then seek additional funding. And I think that's what this tries to do. It doesn't go in to try to solve all the problems, but it does say, hey, can we solve some? Can we show we understand the importance of preventing homelessness? And this is a step towards that. So,
Thank you.
yes, ma'am.
Thank you, Representative Kahan. Representative Griffin?
No, oh, okay,
Oh.
so I'm looking at it.
Okay.
That is good.
Representative Barry?
I didn't think I was on again either. Sorry.
Did he say no?
I realized mine was on.
Okay. All right, what's the pleasure of this board? I have a due pass. Do I have a second? I have a due pass and a second. Is there anything further? All those in favor say aye. And those opposed. Thank you.
Thank you, committee. I appreciate you very much. I know it was a shotgun wedding. I apologize, but we appreciate your commitment.
And we are adjourned. Thank you, everybody. I so appreciate it.
Not yet. They're bringing it. Unlike typical government, we're going to start ahead of schedule. We're a minute ahead of schedule, folks. I know that's hard to believe. So we have before this committee, we call it to order. And we have House Bill 566 with the author of this legislation. Please slide up to her walk-up song. Probably going to let this play till the meeting was supposed to start. All right, we better calm down. This thing's going to get real aggressive in a minute. All right, Leader Hong.
All right, thank you, Chairman. Good morning. I have before you HB 566, and you should have a sub LC 590126S. We're calling this No Fakes Act. It stands for the Nurture Originals, Foster Art, and Keep Entertainment Safe Act. As many of us saw last year, we had the Deep Fake Act last year that was brought up, I believe, by Chairman Thomas, where we saw firsthand our elected officials' voices, likeness, being copied by AI and seeing us saying things that we've never said. And as AI continues to grow and become more popular, we're seeing more things that are protected that are being replicated. And so this bill will continue that protection for artists, for voice and visual likeness as well. And I know AI is still very new, and a lot of people are scared and excited at the same time with the technology, but we want to make sure that Georgia gets ahead and protect our artists as well. So this is a bipartisan bill that will protect voice and visual likeness of all individuals from unauthorized computer-generated recreations from generative AI and other technologies. AI has opened new worlds of creative opportunities, providing tools that encourage millions of people to explore their own artistic potential. And along with these creative benefits, however, these tools can allow users to exploit another person's voice or visual likeness by creating highly realistic digital replicas without permission. Recently, there was a song called Heart on Sleeve, which was created with AI, with the voices of pop stars Drake and The Weeknd, and it accumulated hundreds and thousands of listens on YouTube, Spotify, and other streaming sites before it was identified as fake and removed from the platforms. Last October, AI generated a version of Tom Hanks, and it was used in advertisement for a dental plan that he never appeared in or otherwise endorsed. This bill will address those non-consensual digital replications in these kinds of audiovisual works, images, or sound recordings. Again, we're protecting individual rights, and that is what this bill does. We're not saying that they cannot be used, but they need to have permission in order to use, in order to protect individual rights. The bill it's a long bill, and I can kind of go over a few things here. And essentially, we have the first part of the bill essentially goes through and identifies what and defines what certain what we're looking at as far as voice and visual likeness. In addition, we wanted to make sure that we protect the online service, so social media platforms. And we made sure to include it as them having actual knowledge before they are actually liable. So if they have actual knowledge and they don't remove the fake AI, then they will be liable at that time. So we wanted to add the protection for the online platforms as well. Additionally, we have included, and the sub basically included the Secretary of State as keeping a registry for those artists that have already passed, and making sure that their rights are protected as well. So there'll be a registry. So if anybody wanted permission for any visual or voice likeness of artists that have passed, they can go on the registry and find who to contact, et cetera. So it makes it easier for people to find and get permission. And then we included civil penalties, essentially for violation, and that's kind of the end of the back of the bill. That is essentially the bill. I can go more into detail, but I have also, Chairman, I have two people that will be appearing virtually, and they are in support, and they will also help me answer any questions that I may not, because they are more familiar with this area. And I'll take any questions.
Thanks so much. Do we have any questions for the author? Or we can allow some testimony and then come up with questions at the end. We can follow back with her. You just let me know what the will of the committee is. There we go. I got a little action. Number 8.
I'm just curious how much the Drake video raised before they realized what was going on, and where did did the person that faked it get to keep the money? Or do you know?
I don't know, but I'm sure, I believe maybe the people that are
Okay.
going to appear virtually will know. I'm
Gotcha.
sorry about that.
No, no problem.
Thank you for bringing this. I think it's great. Even the acronym is great. That was pretty creative of y'all. Just want to be sure that this does not limit the ability for original artists to do AI music. As many folks know, there is music that is completely AI. And so just to make sure this bill doesn't limit that in any way. Also curious if you had considered adding something to say that this would not limit that.
It does not limit that. Again, this is a replication of any voice or visual of any individual. So we're very, again, in definition and in the way that we wrote the bill, we wanted to make sure that we're protecting individual rights and AI not replicating those voice and visual likeness of those individuals. So I don't think that it's necessary that we specifically add any language for original AI, because I think the language that we have here will specifically state that it is a replica, not just original AI.
Number 9.
Chair. Good bill, but one of my concerns are how this will be enforced globally, because of course the impact can come from anywhere.
So again, I understand that several states are dropping bills like this in order to protect in each state. So obviously we're state legislators, and so we are enacting this in order to protect those that are in our state that are violating, and hopefully we have other states that are going to enact something similar. And so anything legally, when you're bringing a civil case, there's jurisdiction that are already set. So jurisdiction, domicile that you have to show when you bring any civil action in any state. So that's already been set in our civil statute.
All right, let's go ahead and do we have a list of people signed up to speak on the matter? We can go online if you want to go online first and get those folks out of the way, and then we can deal with what's in front of us if that's comfortable for everybody. Can you tell if everybody's online ready to roll? All right. Which one? So hopefully we're going to reach out to Tom Mann with the Computer and Communications Industry Association. If you guys will Line them up. Who's supposed to line them up? Or do we need to text him? He said he's monitoring. All right. Everybody have a good weekend while we're waiting. Good. Set uncomfortable silences. Sorry we drug you out this early. It's gonna be a busy day.
Thank you, Mr.
Okay.
Chairman. Thank you for the opportunity to speak today. My name is Tom Mann. I serve as the State Policy Manager for the Computer and Communications Industry Association. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. Proposed regulations on the interstate provision of digital services therefore can have a significant impact on CCIA members. We certainly understand the importance of ensuring computer-generated content or automated tools like artificial intelligence are not used for nefarious purposes. Even so, it is impossible for the developers or deployers to predict how each and every individual may use generated material. Legislation should hold the bad actors accountable when they knowingly and intentionally exploit a person's likeness without permission, not the intermediaries. Furthermore, the bill would create a whole new right of publicity statute and would extend postmortem rights to 70 years without creating a registry whereby licensees can locate rights owners. Other states with a strong recording artist presence, such as New York and California, have extended postmortem rights to 40 years and created such a registry. CCIA respectfully requests that the committee not move this measure forward. And thank you again for the opportunity to speak today.
Thank you very much. Does anybody have any questions for Mr. Tom? He is against the bill. It's brought up some good arguments. Anyone? All right. Well, thank you so much for being here or being there. Have a good day, Tom. Thank you so much.
Thank you.
And we're going to call Jessica Richards online. She is the Recording Industry Association of America.
Good morning, and thank you for having me here and taking this important bill under consideration. My name is Jessie Richard. I am the Senior Vice President, Public Policy at the Recording Industry Association of America in DC. We represent the recorded music industry, major record labels here, and of course have had firsthand experience with the very harmful impacts of unauthorized deep fakes over these last few years. They can have not just standard commercial financial impacts of the kind that the representative mentioned on Spotify or YouTube by raking up listens that otherwise would go to authorized individuals or their actual art, but also can have huge emotional, reputational, and other non-strictly financial impacts that this bill would address, which is very important for recording artists when eating away at their market, harming reputation or harming relationships with fans can have a huge impact. And this bill addresses all of that. It does so in a balanced manner that doesn't harm innovation, doesn't impose unfair liability on platforms who have no awareness of any sort of infringement taking place. Instead, it provides a safe harbor to them and only imposes liability when they have actual knowledge that there are unauthorized deep fakes on their platform that don't belong there. I'm sorry, I'm looking at my list of questions that people have asked so far so that I can address them. It doesn't stop individuals from making music. It stops individuals from using another's voice or another's likeness without their permission to do that sort of thing. At the heart of this bill is a person's autonomy, their ability to control how their own voice and likeness are used. And this should take the form of a property right that then they can enforce against. My understanding with respect to Mr. Mann's testimony is that the latest substitute does include a registry for the postmortem rights. We support this bill. We are very grateful to Representative Hong for introducing it and explaining what it does. I'm happy to answer any questions as well. This is important to artists that are the foundation of my industry, the music industry. because it's what allows their voice to be theirs. They've built careers based on their unique traits, and currently there is no legal framework that allows for easy enforcement here. There's no federal law at this time, although we're working on one, but states right now have the ability to provide these protections where they don't exist, and they don't currently exist in Georgia. So this is really an important bill, and we appreciate your consideration, and I'm here to answer any questions if you have them.
Well, it looks like you do have some questions, so we're gonna go to number 4. Maybe. We just,
Yeah. Thank you, Mr. Chairman. Thank you for testifying. Could you speak to this this domicile issue that seems to be created in this substitute, where it appears to me, and I certainly would like to understand more, that potentially a party outside of Georgia could file a lawsuit in Georgia against a party not domiciled in Georgia. Is that correct?
So what this bill does is it leaves intact Georgia's existing laws about who can bring suit and what jurisdiction the courts have over individuals and cases and controversies. So it doesn't touch Georgia's long-arm statutes and how it currently deals with litigation and who can bring a suit. It leaves it to that framework to determine who has a right to be here. Obviously, that entails impacts in the state of Georgia, and Georgia will apply its own metrics that it already has to determine what's appropriate and what's not.
Yeah, I'm not completely confident that meets our intent here in Georgia to reduce the number of lawsuits that we have in the state. Just something to consider.
number 8.
Thank you, Mr. Chair. So I'm just trying to figure out, so if my 17-year-old creates a meme with AI with the likeness of an artist, I can be and puts it on their social media, I can be responsible for their behavior. Or they receive it on see it on social media and repost it. Is that also a violation?
So this bill has a series of exclusions for First Amendment permitted types of uses that likely would cover the types of memes that you're talking about.
I understand the intent, and I'm in favor of the intent. I just am envisioning, I don't want to be responsible for a 17-year-old that
Understood.
at $5,000 a pop.
Yeah, and we may need to talk to the changes on the legislation since we've last seen it, because I don't see all that either. And we can get
Where it discusses, apologies, I didn't mean to interrupt. It's in the section that discusses exclusions and mentions, for example, parody and satire and commentary and
yeah, I don't see that.
I don't see that either.
I don't see that.
No, we did just get it. It's early, but
But that would be good.
it's on page 8
All right.
at line, or I guess it begins on page 7, line 161.
Negligible. Doesn't say. Okay. I mean, I think probably the conversation could be made that could be some language added in that area to protect children and parents of children. Number 3.
Just questioning, so somebody would go to court to prove that it was a parody or satire? Like, would they already have been sued at that point? And if so, what court does it go to? Like, is this a small claims magistrate court? Just, I don't understand.
Well,
No,
in theory, the person, it's not a violation for it to be posted if it's a parody or satire. If somebody does remove something and the person who posted it believes it is legitimate, then you would go to court for reinstatement of it.
Right, and which court is that?
I'm not familiar with the entry level Georgia State court that would be appropriate, but I assume there would be a district level court there. I defer to experts on the Georgia
You would
judiciary.
go see, Judge Gunner. All right, thank you so much. No more questions. Thank you for being here. We're going to move on to Todd Dupler. How interesting. Of the Recording Academy.
Good morning. Thank you so much. Yes, my name is Todd Dupler. I'm the Chief Advocacy and Public Policy Officer for the Recording Academy. The Recording Academy is best known for the Grammy Awards, but we're a membership organization representing over 16,000 individual music creators and artists across the country. Since 1967, we've had a robust chapter in Atlanta representing music creators across the state of Georgia. Our members run the gamut from R&B star Summer Walker to Crowder, from Zac Brown Band to Chris Ludacris Bridges. So all genres of music and all sorts of artists and musicians. I'll kind of reinforce what Jesse just said on behalf of the RIAA. We know in recent years, Georgia has become a magnet for attracting creative talent across the country. As Georgia continues to lead the way in this space, it's important for them to protect the individual artists and creators who are the backbone of this creative economy. But I think it's also important to note that the protections in this bill don't just extend to artists and celebrities, but also to all individuals. To one of the points made earlier, musicians and artists love new technology and love embracing new tools to create. AI is certainly an important tool that has the promise to lead to more music creation and allow more people to have the ability to create. At the same time that we use AI to create, we don't want the AI to use us. And that's really the point of this is to protect the individual, that you can control how your own likeness and voice is being used and manipulated. And if somebody else is doing that to you, you have the ability to stop it. And so again, we think it's effective. It strikes an important balance. It includes, again, some of the provisions that Mr. Mann mentioned earlier as objections. It does have the registry for postmortem in the substitute version, and it does have a high standard of actual knowledge for liability. And so again, the point isn't to punish people, but it's really for you to have the tools to control your own likeness and voice and be able to remove unauthorized uses when they occur. So again, we appreciate the representative for pushing this bill forward, and we encourage everyone on the committee's support. Thank you.
I actually have a quick question for you. What Tom, our first speaker, spoke about the movement from 40 to 70 years. Obviously, you'd be for that, but do you see changing that as a red flag to the other side? And what are your thoughts on that? Obviously, with technology and AI's ability to go back deeper into the world and recreate things, I understand why they're pushing that, but I think that's a pretty big movement from a licensing standpoint.
I think for our perspective, postmortem rights are critically important. If you think of great artists like Ray Charles, and increasingly these artists and personalities have a long tail, and especially in the digital era, there's more potential to exploit someone's likeness and voice after they die, and to commercially exploit them. So postmortem rights have always been important for the family members and estate members of those, deceased celebrities and artists. And so we're in favor of a long postmortem right. We're certainly open to have conversations about the appropriate length and what that should look like, but we support what's in the bill.
Number 6.
I imagine we already have postmortem rights in code, right? Because today I couldn't go use Ray Charles. So is this?
That's right. I'm not sure what the existing postmortem duration is. I'd have to check on that and see what the material changes here.
Okay. One other question, in other states, it's interesting we're housing this under Secretary of State, and this may be for the author. Do they have the capability to do this? And do other states house it in that area?
Go ahead. But yeah, they have been provided with the sub, and they know that they they haven't objected. So we've checked with them and we've provided them with this.
Any other questions? Thank you so much. Appreciate you being here or being there. And we actually have Mala here today instead of online, so that will end all the online testimony. Mala, if you want to slide up to mic number 2 over there. You are live.
Thank you. Thank you, committee and Chairman Carpenter. My name is Mala Sharma, and I'm the president of Georgia Music Partners. We are a trade organization based here in Georgia that represents the 70,000 Georgians who make a living in the music industry. That is the studio owners, the songwriters, the musicians, music educators, and we appreciate Representative Hong bringing this bill forward. This bill to us is very important. It sends a message that Georgia is here to protect the intellectual property, which is the voice and the brand that these artists create, their music. And they've invested a lot of their time, creative energy to make music. And so, these protections are essential for our music creators, songwriters, producers, not only to safeguard the legacies of icons like Otis Redding, James Brown, the Allman Brothers, but to show our up-and-coming songwriters that Georgia values their work. GMP is proud to be a part of a coalition of organizations. It's over 200 organizations that are part of, it's called the Human Artistry Campaign, that all support this no fakes legislation. Groups like the Songwriters of North America, SAG-AFTRA, Music Artists Coalition. Together, we strongly support this legislation and ask for your favorable consideration. And I think the opponents of the bill may try to confuse or complicate the issue, but the reality is simple. This legislation is merely requiring these companies to obtain permission before the use. That's it in a nutshell. I'm not an attorney. It's very complicated when you look at it, but the crux of this bill is just get permission from the person that you're taking their likeness or voice from before you do something. And I think we all want that kind of protection for ourselves as well.
So would it be fair to say permission and pay?
It's permission. Sometimes there is no pay.
Yeah. Okay.
In the case of the parodies, it's you're just asking for permission.
Fair enough. Anybody have any questions? Anyone? No, you got through pretty cheap. Good for you. Anybody else would like to step up to mic 2 and say anybody against the bill that would like to discuss the bill? All right, witness 6.
Just another question for the author, sorry. Line, like starting at 194, I was trying to read that section about an online service should not be liable. What is an online? Is that like ChatGPT or?
We have it defined. There's a definition in there.
Okay.
Essentially any type of platform, social media platform. It's on line 35.
Okay. Gotcha. So you're contemplating Instagram, TikTok. Yeah. Okay.
All right. Go ahead. One sec.
Sorry.
Go ahead.
Chairman, if I may just address Chairman Bonner's, I know he's not here anymore, but just on where this type of case will be brought, et cetera. So just our civil law, civil case law in general, if there is an act that was committed in our state or the individual resides here, that's when you are able to bring a civil action in Georgia. So this bill essentially that's how a civil action is brought. So when one of our witnesses testified, we're not changing that at all. And then as far as which court it's going to be brought to, it depends on the amount that can be collected as damages. And in our bill, we have the civil liability as
I think it's $5,000.
5,000, and that's on page 11. So therefore, it would be brought in Superior Court.
'Cause I have a feeling it's going to be a bigger number than 5,000. I'd say they're going to go just my experience. So basically you're saying either the musician resides in the state of Georgia or the cheater lives in the state of Georgia, or the occurred.
Or
The deep fake occurred. All right. Number 3.
My first comment was to the Georgia Music Partners. I wanted to thank you for your commitment to diversity, equity, and inclusion. It is visible on your website that you include gender identity, and I'd like to really publicly thank y'all for that. But to the subject of the bill, sometimes with AI, it's difficult to find who the person behind the AI is. So who are the minors that are figuring out who that person is? Like, what job is that before it reaches the court?
I mean, I would assume that it would be the artist or the team of the artist that may see something distributed that is not themselves. That's, think about it as us. I mean, if somebody replicates us, and again, we saw that last year, somebody comes with Sue Hong saying a bunch of things that I didn't, then it would either be somebody that knows me or me seeing it firsthand. So it's anybody that can detect that it's not the actual individual, that whatever the visual or voice is distributed is not the actual individual themselves.
But only the owner of the music is able to do the lawsuit.
The holder of the right, correct.
Right. So typically that's not the artist. Typically that is their management.
Whoever holds the right.
Typically, not the artist. Thank you.
Would it be fair to say that if the artist doesn't own it, then he actually sold that right at some point during the stage of his career or her career?
Could be. It's whoever the holder of the right is, correct.
Thank you. Number 8.
Okay, I'm generally in favor of this bill. I know I'm harping on one particular issue. On the part, actual knowledge is required, but is it the parent that receives actual knowledge before they can be held liable for their minor? Because it doesn't read that way to me. If we could.
Where are you looking?
So, it requires actual knowledge in that. What section is that? But it says a civil action for a violation of this code may be brought by a right holder if the individual is younger than 18 years of age, a parent or guardian of the individual. My point is, if they notified the minor that it's a violation and minor doesn't take it down, can the notice be required to the parent? Otherwise, the parent's getting hit for $5,000 a pop and doesn't know about it.
I was thinking that was in regards to artists that were under the age of 18. Can y'all confirm that?
Oh, I'm sorry.
So they're basically saying if your action can be brought by the guardian if the artist is under 18. Is that?
That's
No.
correct.
Well, it says the following activities shall be Oh, wait, we're
No,
on
a civil action, so line 257, a civil action for a violation of this code section may be brought by.
So sorry, never mind.
Correct.
This is protecting the children's.
Sorry. It's too early. I'm sorry, y'all.
That's okay. Number 10.
That answers my question.
Okay.
Thank you.
So, and I don't know if you're the correct person, Sue, to ask her about this, but this seems like this renewal every 2 years, every 5 years. Is there something already in place and not in regards to AI that this kind of licensing renewal process happens? I mean, what's the industry standard in other areas versus, because it seems to me like this is, hey, every 2 years you got to re-up, you got to re-up, you got to re-up. It seems like a challenge.
I don't, but I think maybe if Miss Richards is still on, she may be the right person.
Well, I'd have to look again at the renewal. I know that the idea, the concept is that the right doesn't exist in perpetuity if it's not being used. So for the postmortem right, the ability to continue holding the right rests on continued use. And if use isn't continued, then the right will expire eventually after that initial 10-year period. So that's what the renewal, I have to revisit the text to determine how much active renewal is involved with the Secretary of State's office versus just the registration going forward. But the intent is not to create an overly burdensome system that requires too much engagement by the state and maintenance of that.
Okay, and just a question for you. So let's say I paid for the right to AI generate Robert Johnson. What if I don't use that right within 5 years? I use it or lose it. Is that what you're saying, or?
So this is all, we're talking about the postmortem right now. And so it lasts 10 years after the death of the individual. And then if you're not using it, it would expire. So that would limit the duration of what you've acquired. There is a use it or lose it component after that 10 years.
Okay. And then my question would be, how is that handled now without AI? How is
Well,
that right handled today as we talk about it?
So in the state of Georgia, there is no statute for right of publicity. The courts have said there is a postmortem right. I don't believe there's a limitation on it. But there is no kind of analog that we can point to because the right doesn't exist as to AI or otherwise currently in statute.
So surely, I guess, is each state different? I would think there would be federal law that would tell us how long somebody has the right to use something that they paid for. Like, for instance, Otis Redding's estate. If somebody paid Otis Redding's estate $10 million to use that right, what's the rule now, I guess, in that just if it's just lyrics and music, not AI and if that makes sense.
Right. So copyright is federally protected. And there is a duration for copyright that's 70 years after the death of the author, if it's an individual author, or 95 years if it's a corporate or work for hire. So that's the analog in copyright. There is no federal publicity right or right to name and likeness or in voice and likeness currently. So
Okay.
the
So
70
it's
years is akin to the federal copyright term.
okay. Number 6.
On AI is still pretty nascent, but have other states passed this legislation, and if so, which ones, and what's the status?
In Tennessee last year, the Elvis Act passed into law. It protects voice and likeness in the age of AI. The text is different from the No Fakes Act here, but there's a similar objective. So that went into law last July. And modifications were made to California's postmortem protections last year also. That included a similar definition of digital replica and similar aims. The No Fakes Act language you have before you is not currently passed into law in other states, but it is the subject, it has been introduced in several states and is the subject of discussion and debate, as well as in the federal realm.
Thank you. Yeah, sometimes we wait on the feds to do the right thing. It's a little challenging. I would agree with that. Number one.
Thank you, Mr. Chairman. Rep. Hong, on page 4, line 78, getting back to that 2-year period, what is active? So what's running through my head right now is Disney has the rights to my likeness and my voice because of projects I've worked with them, but it's within limited capacity within the contract that I've signed with them. And I'm wondering if this would override that. What would active be? Would it be that specific project that goes on? So I'm on an episode of She-Hulk. And so would it only apply to that project, or would it apply to every project that Disney does? And so I'm trying to figure out what active would be.
I think it'll be to the courts in each case on a fact-specific basis to determine what constitutes an active use. In the sound recording realm, commercial availability on a streaming service, for example, would constitute active use, but what they're looking for is active use of your right to your voice and likeness in a digital replica. So it would have to be specific to the performance of your digital replica that you authorized.
Okay, thank you.
So how do we intend to, and Representative Hong, actively educate digital content creators on the passage of such a law? How would they get information just to be aware of the risk?
I think it goes with every law that we pass. But I think for the most part, I will tell you that as soon as I dropped this bill, before I even gotten a committee hearing, I've been reached out by pretty much every recording, motion picture, the industry people regarding this bill. And again, this is, Georgia is one of many states that are trying to get ahead with AI. And we're seeing similar bills in other states. So there are definitely people in the industry are keeping up with what the states are doing regarding AI and this type of issue.
Okay, thank you.
Number 6, you wave. All right. So looks like this thing is locked up. All right. I guess that takes care of all the questions. Any other thoughts on the legislation? Committee.
Second.
We have a motion and a second. Any amendments? Anybody? Thoughts? It appears that this, and you confirm if I'm incorrect, but it appears there was some fear. The first speaker online there was some fear about the intermediaries, and it appears that's out of this legislation. Is there for the folks that, basically you're suing the person that did it, not the vehicle with which he did it.
Correct. And
So we're focusing on the bad actor, not the way the bad actor performed.
correct.
Correct. I got a bill in judiciary later that deals with something very similar to this, and I really I really can't wait to plead my case on that same conversation. So I appreciate you very much. Number 6.
Mr. Chair, just to offer to the committee, we had talked about kind of the 70 years, and I think you had mentioned 40 years. I didn't know if we wanted to make any adjustments to that at all. I'll leave that to the committee. Maybe the author. Yeah.
Any
Seeing no head nods. Yeah.
I'm comfortable with what we have
70.
here.
Yeah.
Well, of course you are. You just brought the legislation.
Wanted to make sure.
70 years is a long time. This world could change a lot. We may be on Mars in 70 years, so none of this will apply anyway. I'm sure that'll be like the All right, so that's where we are. All in favor, say aye. Opposed? All right, the ayes have it. Let's go to rules. Thank you, guys. Appreciate
Thank you
you
so
being.
much.